going to introduce Gov. He doesn't need much of an introduction, but he's amazing and is going to share information with you. So
You turn that one off.
there we go.
So this one works. This one works in the room too, in
It
addition.
works in the room.
Okay.
And
Cool. Hi, everybody. Hi, Zoom people. This morning we had a full room because we had nobody on Zoom, but today we have 5 stalwart people in the room and a bunch of you on Zoom, which is good. And if you don't know me, I'm the attorney in charge of the legal hotline. If you have a legal question, free legal advice, free. Call as much as you want. And it's actually the best time to call because unfortunately, as you know, the market's slower. When the market gets slower, we get fewer calls to the legal hotline, which means if you call right now, you'll get right through. 60 seconds or less, you'll be talking to an attorney. So it's a good time to call. I wish you had more business, but it'll get better. The other part of my job is what I'm doing today. I finally, after 2.5 years of Zoom only, I'm finally going out and see you guys in person, which is so great to see you guys. What I do is I try to update you on all of the legal changes that have happened. Typically, that means new laws, that means new forms, and it means sometimes new lawsuits, things to talk about. Okay, so we'll probably start with the laws and then I'll talk about the forms. If you have any questions, just raise your hand. If you're on the Zoom, just put it in the chat, and Jody, just interrupt me anytime you get a question. All right, couple of big things. You know, in the last 2.5 years, I've done like 500 Zooms. I have Zoom fatigue, but anyway, so I'm tired of Zoom, but I'm still doing it. Anyway, but you know what the 2 things I spent most of my time talking about on Zoom the last 2.5 years? COVID and evictions. Thank goodness I don't have to talk about COVID anymore. There are no more rules on that. And I don't have to talk about evictions anymore. As of September 1st, the California eviction moratorium is over. You can evict people just like you always did. But what people forget sometimes is right before the pandemic, if you remember that, right before the pandemic, there's this new law called California rent control was passed. And then we didn't even think about it during the pandemic. Now the pandemic's over. But did you know we have California rent control? You know what that means? I mean, maybe if you're in San Jose, your property is under San Jose rent control. But even if your property is not under San Jose rent control, if your rental property is 3 or more units and 15 years or older, you're under California rent control. California rent control means 2 things. Number one, it means you can't evict someone without just cause. If you're not under any rent control, you don't need a reason to evict someone. You ever have a tenant and you know you're just kind of sick of them? You're kind of bored with them. So you give them a 60 days, you got to leave. And the tenant says, "Why are you kicking me out?" And you say, "Because you're boring. That's why. You know, I don't need a reason." That's actually true. But if you're under California rent control, you need a reason. Like you want to move in, you want to sell it or something like that. So keep that in the back of your mind. I can't just evict people if I'm under California rent control. But did you know this? The tenant doesn't get that protection on California rent control until they've been there a year. So the problem is, what do most landlords do when you get a tenant? You sign him up on a 12-month lease, right? 12 months, during those 12 months, you can't evict them because they're on a lease. Then the lease is over, right? Now they're month to month. If you're not under rent control, you can just kick them out. But if you're under California rent control or San Jose rent control, you need a reason. But under California rent control, you don't need a reason until they've been there a month, 12 months. But if you give them a 12-month lease, as soon as the lease is over, they've been there 12 months. You know what I'm telling you here? If you're a landlord, 11-month lease. Because maybe after 11 months, you figured out whether you can deal with this tenant or not, right? Because remember, once a tenant hits the 12-month mark, they're your tenant for life, as long as they pay the rent and you don't want to move in or something like that. But if you do an 11-month lease, maybe you can figure out after 11 months whether this is the kind of tenant you want forever, and then you can keep them there. Whereas if you decide after 11 months, I could do without this tenant, you can kick them out, even though they're under California rent control because they haven't been there 12 months. Now, if you're doing a single family home or a duplex or a newer building, you're not under California rent control. Then you don't need a reason to evict. Under COVID, you did, but COVID's over. So single family homes, duplexes, newer buildings, no worries about why I want to evict you. Yeah.
Just a quick question.
Yeah.
Back to COVID.
Yes.
Did another meeting last week, I think it was Tuesday, where they had an attorney.
Yeah.
talking, and she mentioned that Alameda County still has.
Yeah.
COVID restrictions
Yes.
and still.
Yes. LA County too. So everything I just said is state law. If you live in Alameda County, San Francisco County, LA County, San Diego County, there are still local restrictions. LA County is phasing them out end of the year. City of LA is phasing them out in the spring. I don't know about, does Santa Clara County have any special rules? Okay, yeah. But if any of you deal in Alameda County or San Francisco, yeah, you still got to deal with restrictions. And I'll repeat the questions, Jody. Yeah. Yeah, everywhere. I mean, in other words, if you're in a city, you may come under the city rent control, but even if you're not under the city rent control, you might be under California. It doesn't matter where you are. It applies everywhere. Okay. And one more thing I want to mention before I get off this topic. There's also restrictions on how much you can increase tenants' rent. If you got a tenant right now, I want to increase the rent. How much can I do it? Well, first you have to ask yourself 3 questions. Question number 1, am I under any city rent control? So if you're in San Jose or San Francisco or Berkeley or something, they're going to tell you how much you can increase the rent if you're under their rent control. What if you're not under city rent control? How much can I increase the rent? If you're under California rent control, remember 3 units, 15 years old or older, it's 10% max. Okay. But what if I'm under single family home, duplex, newer building, so I'm not under any rent control? Are there any restrictions on how much I can increase the rent? Answer, there is one. California has this law called the anti-rent gouging law. This law says that if your rental property is either in or impacted by a state of emergency, you can only increase the rent by 10%. What does it mean to be in a state of emergency? Well, your county is under a state of emergency. LA County, where I live, the entire county is still under a fire state of emergency. I have no idea whether there are any portions of Santa Clara County that are under a state of emergency. If you want to know, call the legal hotline or just go to the website, OES, Office of Emergency Services.ca.gov, and you can figure it out. But did you hear what I said? I said, if you're either in a state of emergency area or impacted by a state of emergency. What does that mean? That means your county is not under a state of emergency, but the county right next door is under a state of emergency. So maybe you're impacted by this emergency, which is typically a fire, and you can't increase your rent by more than 10%. To complicate your life even more if you're a landlord, the entire state of California is currently under a COVID state of emergency. The governor just announced it was expiring in February. Good news. Does the COVID state of emergency limit California landlords who are not under any other state of emergency to increase their rent by only 10%? We don't know. Here's what I want. If any of you know a landlord who's not under a local state of emergency and they're a single family house, tell them to increase their rent by more than 10%. See if the tenant sues them, and then tell us what happens. Then we'll have the answer. My serious advice is, since we don't know the answer, the conservative approach for every single California landlord today is do not increase the rent by more than 10% until February. Okay? All right. The other big thing I want to mention before I talk about the new laws is lawsuits. There is a problem right now in California that a federal judge said, and the and the ADA, the Americans with Disabilities Act, applies to real estate broker websites. Other federal courts disagree, but we live where we live in California. If you have a website, it's got to be accessible to a visually impaired person. I know what you're thinking. It doesn't make sense. If someone can't see, of course they can't see my website. True, but visually impaired people have these devices called screen readers. And if they point their screen reader at their computer screen, if the website they're pointing it at has the proper software, they'll actually get a verbal readout, a voice talking, reading the words on the screen. Courts have said California broker websites and agent websites have to have that software. So you might want to check with your website provider. Do you have the proper software so that a screen reader will pick it up? If they say yes, you're good. If they say no, if they say, I don't know what you're talking about, we at CAR have for you on our website a quick guide called Website Accessibility and ADA Compliance. Knowing Jody, she'll send it to you. But it's on the CAR website under risk management. We have about 45 one-page legal quick guides. They're all good. I recommend them. But we have one for that. Now, the problem is there are these attorneys out there and plaintiffs that are just trolling. They're going website to website to website. Then they think your website's no good and they send you a letter and they say, your website's not in compliance. If you give us $10,000, we'll go away. They're not even asking you to fix your website. It's like extortion. And a lot of these, they're sending it to people whose websites are actually okay. What I want to tell you is if you get one of these letters, send it to CAR. We are responding on your behalf to these bad ones. Okay, but that doesn't take away from the first thing I said, which is try to make sure your website is compliant. Okay. All right. Yes.
Beyond that. Said that was a state judge that had.
It's a federal judge, Ninth Circuit.
Is there any appeal to that going on?
Yeah, but who knows how long? Remember how it works? The Supreme Court doesn't have to take appeals. So if they don't choose to take it, it's the law. There are, those are the type of cases that the Supreme Court often does take. If 11th Circuit says this, 9th Circuit says this, that's a perfect case for the US Supreme Court to resolve it. They haven't done that yet, so we'll see. We'll see. This guy knows a little bit of law right there, you know. Did you go to law school? Just kidding. All right, let's talk about new laws. The governor signed 997 new laws. I'm going to tell you about I'm not going to tell you about every single one. I'm going to tell you about 10 of them. What about the rest of them? Who cares about the rest of them? You don't need to care about them. Actually, we have a handout, which I know Jody, who, by the way, in my opinion, is probably the best education director in California. You are lucky to have her. And she'll make it available to you. Anyway, the point is we have a summary on our website of the 25 or so new laws we think you should know about. I'm going to talk about a bunch of them real quick. None of them, I would say, are bad that you're really going to say, oh my goodness, why did they do that to us? I hate the legislature, boo legislature. And as Jody mentioned in her introduction, the reason, probably the main reason there are not a lot of bad laws being passed this year is because collectively the realtor organization, CAR, and on the local level, Santa Clara County, we fight these bad laws. How do we fight a bad law? Well, we have lobbyists. They go to the office of the assembly person or senator in Sacramento and say, there's this law being proposed. We think you should vote against it. And why should they listen to us? Realtors have influence. There are a lot of us. Other people in the community listen to us, and we have money. And they know if they don't vote the way we think they should vote, obviously we try to convince them with reasonable arguments as well, but they also know perfectly well that if we are not on board, if they're not on board with us, we may very well contribute to the other side to help them, their opponent, and they hate that. But they'll also want us to contribute to their campaign. This sounds like fraud and corruption, and this is politics. So the money you work hard to earn and give to CAR or local association goes that way. The more you give, the more we have, the more success we have. This year we had a lot of success. There were so many bad laws proposed that didn't get passed. There was a law that would have said if you buy a house and sell it within 3 years, if you made a profit, you'd have to pay a 25% tax on the profit, above and beyond any capital gains tax. There was a law that said if you sold a house with a tenant in it, you couldn't sell it to anyone except the tenant for like 2 months. You had to give the tenant 2 months to see if they want to buy it. There was going to be increased rent control statewide, more restrictions on a landlord's ability to get out of the rental business, statewide rental registry, a requirement that anytime a tenant had a vacancy, anytime a landlord had a vacancy, they have to pay for a energy efficiency audit before they could re-rent it. There was a law there was a law that was going to try to limit the mortgage interest deduction to primary residences or properties under a certain dollar value. So these law, a law proposing no dual agency, a law proposing mandatory buyer broker contracts. None of these laws are going through because of us. Not only because of us, but partly because of us. So that's just political pitch. So now let's talk about the laws that actually did get passed. And a couple of interesting ones, nothing too harmful, critical, but things worth talking about. Number one, a law I like. Makes it easier for me to do my job. Have you ever been in the middle of a real estate deal and all of a sudden the law changes in the middle of the deal? And you're wondering, do I got to change what I did now because what I did before was okay, but now it's not? Or shouldn't the law, when you enter the contract, be the law that you follow throughout the contract? And that's thankfully what this new law says. AB 2960 basically says, in a real estate transaction, the laws in effect when you sign the contract are the laws that are enforced during that escrow. I mean, your next escrow, of course, you have to follow the new law, but you don't have to change and give them a new form that just came out in the middle of escrow, because when you enter the contract, that law wasn't in effect. The laws that were in effect when you enter contract, those are the laws. I like that one. Just makes it easier for me to advise people. All right. Second law I want to talk about deals with licensing. You'd all be interested in this. There are two types of licenses in California: salesperson and broker. To become a broker, what do you have to do? Well, obviously you have to pass the test. But before you can even take the broker test, you either have to be a salesperson for 2 years, college degree, major in real estate, or be an attorney. New law says if you want to be you have to be a salesperson for at least 2 years. New law says you have to be a salesperson within the previous 5 years. Because maybe they were an agent 10 years ago for a few years, they dropped out of the business. Now today, I want to get back in the business. This time I'm going to be a broker because I already was a salesperson. Well, you have to have been a salesperson within the last 5 years for 2 years. No big deal, but just be aware. Okay, that's AB 2745.
Gov, I have a question.
Yes.
Consecutive 2 years?
No. I don't know why people would be 1 year or not, but 2 years total. Good question. Doesn't have to be 2 consecutive years. A total of 2 years. All right. Another law that's not new this year, this is a reminder from last year, starting in 2.5 months, January 1st, 2023, if your license comes up for renewal, You're all going to have to take a new class on what's called implicit bias and a new expanded fair housing class. CAR has already got our versions approved. We'll offer them for no charge to you as a member. So you're still going to take 45 hours. It's just going to be slightly different. All right. Enough on that. Before I go to more new laws, let's talk about the latest from the DRE. They've made 3 recent announcements that you need to pay attention to. Number 1, reminder. If you're going to refer a licensed contractor to a client, before you make the referral, you have to verify that the license of the contractor is active. So you have to go to the Contractor State Licensing Board website, cslb.ca.gov, check on the license check box, put in the name and see if not only is their license active, but do they have workers' comp for their employees? That'll be right there. If they don't have it, you can't refer them to a client. Can I refer a handyman? Of course, handymen aren't even licensed. Don't refer a handyman. Tell them they're a contractor, though, but you know what I'm saying. All right. Second thing the DRE recently announced is a reminder that, and this is really talking to licensed property managers, but it applies to all landlords. In California, you can no longer discriminate against a prospective tenant based on their source of income. Back in the good old days, from landlord's perspective, or in actually most states in this country, you can refuse to rent to someone just because of what they do for a living. In California, it used to be you could discriminate against lawyers. Would you want a lawyer as a tenant? I wouldn't. So someone applies for your vacancy. What do you do for a living? I'm a lawyer. Get out of here. Not anymore. You can't discriminate on based what they do for a living. But what really matters is you can't discriminate because they're getting a subsidy. Every landlord in California is now a Section 8 landlord. Oh, I don't want to participate in the Section 8 program. You have no choice. Does that mean I have to take every Section 8 applicant? No, of course not. You still screen people. And if they don't meet your standards on income, time on the job, credit history, eviction history, as long as you apply the same standards to everybody, you can reject someone. But if you have 2 fully qualified people and one Section 8 and one isn't, don't reject the Section 8 just because they're Section 8. I know what you're thinking. How are they going to prove that's why you rejected them? Judges think that way. Judges will say you obviously disapproved them because of their Section 8 status. How do I avoid this problem? Take the first applicant who meets your criteria. You can have very high criteria. Your criteria could be credit score, 850, income, $1 million a year. Yeah, but this is just a studio apartment. I don't care, $1 million a year, whatever. Take the first person who meets your criteria, then no one else can complain that you're discriminating. But if the first person who meets your criteria is Section 8, there you go. Here's what's happening, though. The California DRE and the California Department of Fair Housing, they have testers calling up landlords and property managers. They're not real applicants. They're just going to call up and say, oh, by the way, do you take Section 8 tenants? A lot of landlords haven't heard what I just said, and they'll say, no way. They're dead. They're in trouble. They just admitted they're violating the law. So if you're a landlord, you get this question, do you take Section 8 tenants? Your answer is absolutely yes. I love Section 8. I prefer Section 8. You don't have to go that far. But anyways, you see what I'm saying? Okay. Third thing the DRE recently said is,
Got a question on
yes,
Section 8.
absolutely.
What if we accept an applicant's income from Section 8 for qualifying, but refuse to participate in the Section 8 program?
Can't do that. Definitely can't. In other words, and that's a good point, though, by the way, you can have a standard. Applicant's income has to be at least 3 times the rent. But if it's a Section 8 tenant, that means their income has to only be 3 times the amount of their portion of the rent, not including the subsidy part. But you have to participate in the program. All right. Third thing, DRE, quick reminder. You know, you can only work for one broker at a time. So what if you work for broker number one and broker number two has this listing and your friend who's an agent at broker number two says, hey, can you do my open house this weekend? DRE says, you know, you really got to be really careful about doing an open house for somebody else's broker's listing. You can only work for one broker at a time. You can't do license activity for the other broker. What do you do at an open house? Typically, you're talking about the property, you're talking about terms. That's license activity. Does that mean you can't actually do an open house for somebody else? Maybe your broker doesn't allow it. Yeah, you can still do it, but you got to be very clear when you're doing the open house that you put up your own sign or something that's on flyers that say, I am not here as a representative of the seller of this house or the listing broker of this house. I am just an independent potential buyer's broker here to help. If you don't make that clear, you could get in trouble is what they're saying. Okay. All right. Back to new laws. Yeah.
Oftentimes we use signs to direct people in.
Yes.
If we use the generic one that just like.
Yeah.
House. But we have our own business cards that we're handing out at that open house. Would that be enough to see?
His question is it okay if I just, have the generic this way to the open house sign and then hand out business cards with your name on it, your office, not the listing? My implication from what the DRE was saying is that might not be enough. Maybe put up a little sign. I'm Gov from Hutchinson Realty. I'm not affiliated with the listing company here. They didn't make it clear how far you had to go, so it's not clear. Sorry, good question. All right, let's move on. Let's talk about, I talked about all the bad laws regarding rentals that didn't get passed. Let's talk about the ones that did get passed, two of them. One is AB 2559, creates something called a reusable tenant screening report. Reusable tenant screening report. Do you know landlords, if they have a vacancy, they get an applicant. Tenant says, I want to apply for your vacancy. And landlord says, well, I'm going to have to screen you. I use this agency. I'm going to charge you X amount of money to do it. In the old days, landlords could charge whatever they wanted. Then a law was passed a few years ago that says you can only charge them 35 bucks. But that's 35 bucks adjusted for inflation. You know what it is in 2022? $52.46. Nice round number to remember, right? Next year with this year's inflation, I'm sure it'll be like 80 bucks or something. This can add up. If I'm a tenant and I've got to fill in got to make multiple applications, I'm spending a lot of money before I even get in. New law says there's going to be something called a reusable tenant screening report where you can go to an agency and they'll prepare it, certified affidavit, swear to God, saying, all the things the landlord wants to know, eviction history, income history, credit score, blah, 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 criminal record. But the tenant could use it multiple times with multiple landlords over a 30-day period. Good news for tenants. But you know what? Landlords won't have to take it. But I think landlords are going to be willing to take it because it's going to be a certified document that's already prepared. They don't have to take any time to go through the process. So it's probably going to be a possible thing. And now we have 6 people in the room rather than 5. Yay. Do you want her to sign in or you better sign in? You know her. I know her. Good to see familiar faces coming back to San Jose. All right. So that is, if I didn't say AB 2559. The other new law regarding landlord tenant is kind of complicated. It's kind of a little controversial. It's regarding domestic violence. And this is SB 1017. Let's back up for a second. Current law today. By the way, all these laws are going to take effect January 1st. Current law today says if you're a tenant and you're a victim of domestic violence, so you're living with someone and that bad person is doing domestic violence, you can go to the landlord and say, I know I'm in the middle of a year lease. I'm only 3 months in. You need to release me from the lease. You need to let me out because the jerk I'm living with, domestic violence. And the landlord has to let you out. Of course, the question is, what proof does the tenant have to provide the victim to authorize the landlord to have to let them out? The law has never been clear. So, in other words, but if you say no to the tenant, no, you can't leave, I don't believe you, they could sue the landlord. And then if they convince the judge that they really were a victim of domestic violence, what would that proof be? Police report, temporary restraining order? It's up to the judge. But if you convince the judge that the landlord should have allowed you to go, then you get to go. New law says, landlord, if it's decided that you should have let them go, but you didn't, you can get fined $5,000. What's the moral of this story? Let her go. Oops, I said her. It's probably a her, in my opinion. Okay, it's not always, but anyway. When in doubt, let her out. Don't contest her allegation that she's a victim of domestic violence, because if you contest it and she challenges and you lose, not only do you have to let them out, you're also going to get fined $5,000. That's point number one. Point number two. Let's say the victim tenant says, you know, I don't want to leave. I want you to kick him out. I want you to kick bad person out. Under current law, you don't have that right. January 1st, the landlord would have to say, okay, I am going to evict the perpetrator. You can stay. Once again, the question is, what proof do you have to provide to the landlord? And once again, here's how it would work. Victim says, kick jerk out. So you give a notice of eviction and they don't leave, and you file an unlawful detainer. You go in front of a judge. And the alleged bad person can try to convince the judge they're really not bad. And the judge is going to decide what level of proof the alleged victim has. But as a landlord, don't even think about that. If one of the tenants says to you, kick out bad person, go through the process. Attempt to evict. Otherwise, you don't want the consequences of being accused of not responding to this. So it's interesting, but that's what you got to do. The law also says, though, that the judge, first of all, also has to require the landlord to change the locks. But then the law says the judge can say to the victim, all right, you can stay, bad person has to go. But if you allow bad person to come back, now the landlord can kick you both out. Because this unfortunately happens in the real world. Sometimes the forgiving, oh, you can come back. No, you can let them come back. The landlord can say, I don't want to deal with this situation anymore. You both got to leave. I'm terminating the whole tenancy. Plus, the law also says, if the alleged perpetrator is not just being bad to the victim, but also is posing a threat to other tenants. Because sometimes you got this jerk, he's threatening everybody. You have a duty to your other tenants to protect them from bad people. So that would give grounds for the landlord to evict not just the perpetrator, but the victim too. You're basically saying, I'm sorry, you're a magnet for this evil person. Evil person is posing a threat to my other tenants. I actually have an obligation to terminate the entire tenancy to protect my other tenants. This gets very complicated. I always advise landlords, before you evict someone, you have any doubt in your mind about one of these issues, get a lawyer advice to do it the right way. It gets more and more complicated every day to be a California landlord. Okay. All right.
I have a couple questions. It's kind of the same question on Zoom. And then we got another one. So there's questions about qualifying to be able to pay.
Oh,
So
yeah.
What happens if
Yeah.
who's ever there
Right.
pay?
Here's a good question. It turns out that the one who's supplying the income to pay for the rent is the bad person. So victim says, kick out bad person. Landlord says, yeah, but they're the one supplying the money. can the landlord now demand that the person who's remaining qualify on their own to pay the rent? No. But of course, if they don't pay the rent the next month because they no longer have money, the landlord could terminate the tenancy based on non-payment of rent. Don't have to give them a break or something, but they can't demand that they qualify in order to stay. Okay,
Couple of questions.
yeah,
In the reverse,
yes,
victim says,
I want to leave. Yeah.
Can the lease be vacated at that point?
In other words, that's a good question. I've never seen that actually a landlord challenging. In other words, the landlord is nice enough to let them out. And then what? What are you saying? They leave, but the bad person stays and then they move back in with the bad person?
Yeah.
Law doesn't address that.
Okay.
I could see a landlord saying to the judge, that's wrong, blah, blah, blah. Whatever. I don't know. Yeah.
Second.
Yeah.
Victim gets the moneymaker. The
Yes.
moneymaker continues to pay the rent,
And the landlord takes it. Well, good for him.
right? But now that moneymaker has possession of the property.
Nope. Definitely not. Yeah.
Different than what I heard today. Someone on it.
Huh.
It's the collection of rent from a non-occupied person. It's that non-occupied
No.
person.
Hey, when I was younger, I paid my girlfriend's rent. I wasn't living there. I
Just for
didn't
those
have any
on-
rights.
For those on Zoom, just to.
I'm sorry, I
guys-
should have repeated.
No,
that.
that's okay. The question was if I'm calling him the perp. If the perp leaves but is still paying the
Yeah.
rent, the question is,
Yeah.
does that payer
Acquire
have
rights.
possession of
They really
the
don't.
property? And
They
they
really don't.
do not have possession
Right.
of the property, even though
Right.
they're paying for it.
Right. Good summary. Thank you. All right, let me keep going. Enough on rentals. No more rentals. HOAs, new law, AB 1410 issue. Can a homeowner association tell the unit owners you can't rent out your unit? Answer. HOAs have to allow at least 25% of the unit owners to rent it out. If they're already 25% renting it out and somebody else says, I want to rent it out, the HOA can say no. That's not the issue here. The issue here is, what if I just want to rent out a portion of my property, the back bedroom or something? Does that count towards the 25%? No. So you have an absolute right. HOA can never stop you from renting out a portion. Okay. By the way, different question. HOAs definitely can prohibit short-term rentals of less than 30 days, like Airbnb. Next question, next issue. There's been some clarification of Prop 19. This is SB 989. First, I'll give you all the background. The background is, in California, your property tax is usually based on a percentage of the purchase price you paid for the property. However, if you're over 55 or severely disabled, or your house has been damaged in any way by a wildfire, you can sell that house, buy a new one, but you can transfer your property tax on the old one to the new one. In other words, the property tax on the new one is not going to be based on the purchase price. That's the general rule. That's good news for people of a certain age. Because you could have bought, let's say you bought a house in San Jose 40 years ago for $100,000. It's now worth $1 million. Your property tax is still based on 100,000. You finally want to sell for, you sell for $1 million. You buy another one for $1 million. Your property taxes won't go up at all. What if I want to sell for $1 million and buy another one for 1.1 million? What will my property taxes be on my new $1.1 million house? It'll be the original 100 plus 100, the difference, the increase of the purchase price of the replacement from the sale price of the original. It'll be a total of 200, which is a heck of a lot better than 1.1 million. That's the basic rule. And you can do this 3 times, and you can move to any county in the state. You can do it, and you can do it within a 2-year period. You sell the original, you have 2 years to buy the new one. You buy the new one first, you got 2 years to sell the old one. You got to be 55. Here's one question, or one point. you don't have to be 55 when you do the first leg, as long as you're 55 when you do the second leg. Second issue, married couple. Do they both have to be 55? No. So all you guys with the young trophy wife, you're good. You can do this. Or vice versa, of course, right? Right. Okay. Okay. All right. All of this is not new. Now let's talk about the new thing. Oh, I'm sorry, one more thing. What if you have a married couple? They're both 55. They have a house together. They've owned it for a long time. Unfortunately, they're getting divorced. Each of them wants to buy a new house. Can they each transfer the low property tax on the house they own together to a new one? No. Do they each sort of get half of it? No. One of them gets all of it. The other one gets none of it. Which one gets it? The one with the better lawyer? No, no, just kidding. The first one that buys. You got to be quick here. So if you're over 55 getting divorced, get your eye on that new house quickly. Actually, the smart divorce lawyer is going to incorporate this into the divorce settlements and is going to say, this one gets the benefit, the other one gets something correspondingly equal in value, whatever. Okay, you got me on that one. Okay, I still haven't talked about the new law. The new law says an interesting thing. This is applicable in LA County where I am. I don't know about here. Let's say you qualify for Prop 19. You sell the original. You buy the new one. You want to transfer the low property tax on the original to the new one. You go to the county assessor's office. You fill out the form. I've done it myself. Very simple. You give them the form and say, transfer my property tax. And they say, yes, we will get right on it. But they're backed up. They're slow. And all of a sudden it's this last week and they send out the property tax bills. They're going to send it out based on the purchase price because they haven't processed your Prop 19 application yet. The good news of this law, which took effect immediately, is if you have filed an application to get the Prop 19 transfer and they send you a bill for paying property tax based on the purchase price, don't pay it. You just simply do not have to pay it until they send you the correct bill taking advantage of the Prop 19. So this is going to give an incentive to the county to not delay. Good news. All right, I'm almost done with new laws. SB 869, mobile home managers have to be certified, meaning they have to take a test, shows they know what they're doing about mobile home law. Good to know. SB 1076. Did you know that if there's a house that's older than 1978, it might have lead paint? Law says if you hire a contractor of some kind to do work on a pre-78 house, and the work that they do is going to disturb more than 6 square feet of interior painted surface or 20 square feet of exterior painted surface, the company that does the work has to be certified as a lead renovator so they know how to do the work without causing a hazard of lead paint being sprayed into the air. Current law says only one person at the company has to be certified. That person can train the other people. New law says, no, that's not enough. The person on site actually doing the work has to be a certified lead renovator. Do you really care? Is this ever going to affect you? Probably not. Okay, but I just threw that in there. A couple more laws. There's a lot of new laws regarding building that CAR sponsored and supported. You don't need to know the details unless you're a builder or a developer. But for example, these are the goal of these laws is obviously to make it easier to build housing. There's a bill called SB 6, which is streamlining the process of converting commercial and retail property into residential, because there's a lot of commercial properties aren't being used now. It'd be nice if we could use them for residential. The whole process is going to be streamlined. There's another one that says if you're building within a city along a major transit corridor, which means a road of at least 4 lanes, not only is the process to convert commercial to residential been streamlined, but the whole permit process has been streamlined. That's AB 2011. There's an interesting thing. Yeah, I mentioned that. California has this. Okay, back up a second. Did you guys all read your any information from CAR that CAR officially, as an institution, apologized for past fair housing practice? One of the things we apologized for, I know none of us were part of this, this is way back when, was we supported this constitutional amendment that says in California, no affordable housing project can be built in a particular area unless there's a vote, a majority vote of the people who live in that area. And this has stymied a lot of housing construction over the years. CAR sponsored a bill that put a ballot initiative on the ballot, and I forget what proposition it was, but it's to eliminate this constitutional provision. No other state has it. I think it's section 34 of the Constitution. I would recommend voting for that ballot initiative. That's just my personal recommendation. CAR recommends that as well. Okay, couple more things real quick. REOs, new law says, and this is AB 2170. If we're talking about a mortgage servicer and they foreclose on at least 175 properties per year, new law says they cannot sell off their REOs in bulk. They can't sell off 10 to this buyer, 20 to this buyer. They can only sell them one by one. The advantage of this, of course, is who can afford to buy 10 houses at once? Like a major investor. But who can afford to buy one? Someone who actually wants to live there. And we want the law to make it easier for people to buy houses to actually live in themselves, so they can only sell them off one by one. Plus, get this, all REOs on all sales have to, for the first 30 days the property's on the market, they can only sell to owner occupiers. I mean, if they want to wait 30 days, fine. But if they're in a hurry to get it off the books, they can only sell to people who actually want to live there. So that's all positive towards homeownership. The last thing to mention is, two ones. One I didn't even mention this morning. You're getting a bonus from the people this morning. AB 916. I don't think I mentioned it. Anyway, let's say you have your house and you want to reconfigure the inside to add bedrooms, build a new wall or something like that. You're not adding on, you're reconfiguring inside. Some cities and counties actually require you to go through a hearing process to just do that. New law says you have an absolute right basically to reconfigure your house to add 1 or 2 bedrooms. I'm not saying building an addition. I'm talking about reconfiguring what's already there. If it's 3 or more, you can still, the county can still require some type of hearing. And finally, the last one, SB 897, ADUs, accessory dwelling units. As Jody mentioned, you're going to have a class on that. I recommend you go. General rule. In California, you have the right to build an accessory dwelling unit. And we all talk about SB 9 and 10. You're going to have a seminar on that. You should probably go, which talks about under SB 9, under some circumstances, I can build a second property on my R1 lot. And sometimes I can even do a lot split, create a second lot and put 2 on each one. There are restrictions. HOAs could prohibit that. There are various restrictions. But you know what? If you can't take advantage of SB 9, all of us who own a house in California can build an accessory dwelling unit. Now, the limitation is it can't be bigger than, in other words, the city or county can't stop you. If you build, the HOA can't stop you. You got to meet the building code, but there's no discretion in the city or county or the HOA allowing it. You have the right to do it. No more than, yeah. Great question. I'll repeat her question. So what I just got through saying is everyone in California can build an accessory dwelling unit. In addition, everyone in California can also, or alternatively, build a junior ADU. They can convert their garage, convert existing space into an ADU. That's a total of 3. Yes, you can do that. Well, does that come under rent control? Well, they have to think about it. It depends on when you built it, right? If you built it within the last 15 years, you're not under rent control. Because no properties built in the last 15 years come under California rent control at all. But the house is old, but you're just renting out the ADU. Right. Right. That's a great question. In other words, the junior ADU within the house is older than 15 years, but I just built the ADU. So do I come under the rent control restriction or not? Right? Is that your question? No. Since the ADU itself was built and permitted within the last 15 years, you can charge whatever rent you want. Unless there's, yeah, right. Great question. Yeah. Yeah. But it's re-permitted and stuff. Yeah. Very good question. Okay. So anyway. Yeah. Yes.
Reconfigured, is that just the existing living space?
Yeah.
Or would that also include the garage?
Yeah, including conversion of the garage, right? Not just converting, converting garage or stuff that's currently not living space, turning it into living space. You have an absolute right to do it. Yeah. Having said that, the HOA or the city or the county can limit to 800 square feet, can limit to 16 feet high, and can require setbacks. New law that I just mentioned is saying SB 897. First of all, the setback requirements, some cities and counties and HOAs are imposing these huge setback requirements, which in effect makes it impossible to build. The unit law says absolutely cannot do that. I mean, the setback can't be any bigger than, if the setback is bigger so you couldn't actually build the unit, then that setback is not valid. Second, I don't know if I just said this, but the ADUs can be limited to 800 square feet and 16 feet high. New law says in certain circumstances, the ADU can be 18 feet high if the property is within a certain half a mile from a transit stop. If it's within 20, if you necessarily have to align the roof pitch of the ADU to the roof pitch of the main house, it can be 20 feet high. And if the ADU is attached rather than detached, it can be 25 feet high, but still 800 square feet. So I guess they're just going to be thinner and taller, but whatever. So vertical building, right? So anyway, that is all the new laws you need to know about. But we do have new forms to talk about. So let's talk about the new forms, which are sort of related to new laws. CAR does forms twice a year, December, June. What happened December of last year? There was one big change, the new purchase contract. There was another form that came out though, back then, that we've noticed that a lot of realtors haven't picked up on and aren't using it and should be using it. It's called the TOPA, Tenant Occupied Purchase Addendum. Let's say you're writing an offer on a house and there's a tenant there. You don't want the tenant there. So where do you put in the contract you want the tenant out? Or maybe you want them out a week before close. Or maybe the seller says, yeah, but they're on a lease and they got it. I can't kick them out till a week after close. Where do you deal with the tenant on the purchase contract? Plus, second question, what if the tenant's not supposed to be there? I get ready to close and the tenant's still there. I've removed all my contingencies. The seller says property will be vacant. We're getting ready to close, property not vacant. Do I have the right to cancel even though I've already removed my contingencies? Do I have the right to delay closing until the tenant is out? Or do I have to close and deal with the tenant myself? The point is, there's nowhere on the purchase contract that deals with this. which is why you need an addendum to deal with this. You need a form that's going to say when the tenant needs to be out and what are the consequences if the tenant is not out? What are the buyer's rights? That's why I strongly recommend if you ever write an offer on a property that's at the time of the offer occupied by the tenant, you want to specify that. I know the seller always says, oh, that tenant will be gone. Don't worry about that. But you want it in writing. And you also want the remedy if they're still there. I'm just advising it's a good idea to use it because we see what's happening now is people don't use the form. There's a tenant issue. They don't know how to resolve it because they didn't agree beforehand. What happened? Okay.
Purchase contract does have that. There
It does.
talks about vacant property.
Well, there's a checkbox that says, what if it's occupied? There's one box if it's seller occupied or vacant. But then the next line deals with the tenant, but it doesn't give you room to say what's up with the tenant. By the way, since we've noticed this has been happening, another thing that's going to happen in December when the new form comes out, there's going to be a new line added to the purchase contract. It's basically going to say, if you don't use the TOPA, buyer and seller agree that the property will be vacant at close. So it's sort of a default section, but it still doesn't deal with the issue of what if the tenant is still there? What are my rights as a buyer? Can I walk away from the whole deal because the tenant's still there? And I think it's nice to have a form to address that question. All right, so that was December. The next forms were 4 months ago in June. And then 2 months from now, we're gonna have new forms. So first, let me talk about what happened 4 months ago. Then I'll talk about what's gonna happen in 2 months. Okay, all right. What happened 4 months ago? 7 new forms. How many of them were mandatory? 2 of them. So let's start with those. New form came out called for rental properties called the information on dampness and mold for California renters. Starting this year, 2022, anytime you rent a property to a new tenant, you're required to give them this booklet, information on dampness and mold for California renters. Doesn't apply to tenants from last year who still are here. Doesn't apply to old tenants who renewed this year. Brand new tenant, residential, give them the booklet. We've attached it to the CAR lease form. If you lease property using the CAR form, you already gave it to them, you're good. But some of you maybe think to yourself, uh-oh, I rented to someone 3 months ago. I didn't use the CAR lease and I didn't know about this new form, so I never gave them the new form. What's going to happen to me? You're going to jail. No, you're not going to jail. No, you're not going to happen. Just give them the form later rather than never, right? Email them. You don't even have to give them a hard copy. You don't need a signature. Email the tenant the form. Now you may be thinking to yourself, that's interesting. Why in 2022 do we have this mold form? Did something happen about mold this year? You're not going to believe this. No one in this room, I think, with possibly one exception, was in the real estate industry in 2001. Was anybody in the industry in 2001? He and I remember in 2001 was the year of the mold panic. I don't know what happened, but all of a sudden everybody's talking about mold. CAR, this association would put on these mold training sessions. Buyers would go out almost every deal, they'd get a mold inspection. They'd hire a mold guy to come out with a machine and he would measure how many spores of mold were in the air, 792 spores per cubic, whatever. And then he would tell the buyer, you got 792. And the buyer would say, is that a good number or a bad number? And the mold guy would say, I don't really know. So the law was passed 21 years ago that said, Department of Public Health, you need to do 2 things. Number one, you need to come up with scientific standards determining how much mold is too much. Second, you need to come up with an informational booklet to be given to tenants. Took them 21 years to come up with the mold booklet. I mean, when it came out this year, the attorneys like me who've been on the hotline since then are like, is this the booklet they were supposed to do 21? Yep, it sure is. And they still haven't done the other stuff. They still don't have scientific standards. Do we really care anymore? Does anyone care about mold anymore? We all know we don't like mold, but nobody really measures you tell me, do you have buyers getting mold inspections? She says yes. Every time? Sometimes. Yeah, right. So anytime. Anyway, that's the list on that. It's a mandatory form. Give it to your tenants. Form number 2. This is the only important one. You may have noticed that when you pull up the purchase contract, the RPA, you don't just get the purchase contract, you get 6 other forms. But ever since June 21st, you've gotten 7 other forms. What are the 6 you've always got? You got the agency disclosure, you got the potential representation of more than one buyer or seller, PRBDS. You get the fair housing advisory, the privacy form, the wire fraud advisory, and the inspection advisory. All 6 of those, by the way, are designed to be given to the buyer. I hear agents complain, I can't get the seller to sign. You don't need the seller to sign. The listing agent already gave the seller the agency disclosure, the dual agency form, the privacy form, and the fair housing form when they took the listing. And the other 2, the buyer inspection advisory and the wire fraud advisor for the buyer. So only worry about getting the buyer to sign those 6 forms. And you know what? Even if the buyer doesn't sign them, you're really okay. You gave it to them. They can't deny they got it. They signed the purchase contract, which means they agree to all the attachments. It's not a big deal. They're not required by law anyway. Well, yeah, they are. The privacy one is required by law. But the point is, don't worry about it. The 7th form, the new one, the one that came out July 1st, that's been attached to the contract since June 21st, is called the Fair Appraisal Act Addendum, Form FAAA. It's a required form. And it's required that it be signed by the buyer and the seller. Anytime you see the word addendum, that means needs to get signed or we don't have a deal. So if either the buyer or the seller doesn't sign this new attached Fair Appraisal Act addendum, you don't really have a binding contract. I mean, you have a contract that's binding, but either side can cancel, can walk away up until the moment of close with no repercussions because you never really had a deal because you never had this Fair Appraisal Act addendum signed. What I'm telling you as a buyer's agent, when you submit the offer, make sure the buyer signs it attached to the offer. And when you're the listing agent and you get it, make sure your seller signs it as part of the acceptance process. If not, either the buyer or the seller can cancel the entire deal right up till the end. You don't want that. Okay. By the way, what does this form actually say? Nothing too important. All it says on it is it's telling your buyer and seller, if you just got an appraisal and you think the appraiser is biased, here's where to file a complaint. It's not even a complaint form. It tells you where to file a complaint. But it's important enough that if you don't sign it, either side still has a right of rescission. You don't want that. Okay? If either one doesn't sign it, they both have to sign it, which is unique because you're used to disclosures have to be signed by the buyer. TDS, NHD, SPQ, lead paint, fire hardening. This is a unique disclosure form that needs to be signed by the buyer and the seller.
It's not a disclosure.
It is. It's an addendum, but it's a disclosure. It's a disclosure in the form of an addendum. It's technically a disclosure from the realtor to the buyer and the seller, and it has to be attached to a purchase contract. So we turned it into an addendum. Same thing, even though you're not thinking, but remember, even in a cash offer, the buyer is entitled to an appraisal. It's just a form telling people what their rights are. Just do it. Yes. 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 If even if one signs it and the other does. Yeah, but it's the same thing if both didn't sign it or only one signs it. It's the same thing. I mean, but look at it this way. The transfer disclosure statement. Seller needs to sign it, send it to the buyer. If that doesn't happen, do you actually have a contract? Well, yeah, you do, but it's since the TDS was never properly delivered, you have a contract that can be canceled at any moment. This is the same thing. Without it being signed, you still have a contract. It's just, it can be canceled at any time, which is sort of not having a contract if either side can just walk away with no reason. Which is different than contingent. Remember how contingencies work? Contingencies are like, in this area, I know for a long time, every offer you wrote was non-contingent, right? But isn't that sort of changing? Aren't you writing offers with contingencies now? But if I, as a buyer, want to cancel based on a contingency, I have to act in good faith. I actually have to tell the seller, I'm canceling, give me back my deposit. Why are you canceling? Well, I haven't removed my contingencies. The seller's entitled to say, which contingency are you using? Well, the loan contingency. Oh yeah? I called your lender and they said you did qualify for the loan. So you're not acting in good faith. Whereas this one is not even that. There's no good faith requirements. Just simply, if the form isn't signed, you can walk. Just like with the TDS. I don't have to act in good faith. Until 5 days have passed from my receiving the TDS, I can walk. Now, once again, I know in this area, though, maybe it's a standard practice to give the disclosures to the buyer before they write the offer, in which case, no 5-day right of rescission. Which is why if you sign this Fair Appraisal Act addendum at the time of the contract, no right of rescission, which is why we attached it to the contract, and as opposed to making it a separate form. All right, so that's 2 of the 7 forms. 5 more forms came out in June. 2 of them deal with commercial. If you don't do commercial, you don't care. One is a new commercial seller property questionnaire. It's similar to the residential SPQ, seller property questionnaire, but it's for commercial. Is it mandatory? No, it's a good form. Form number 4, also commercial. You're dealing with a property that's part commercial, part residential, mixed use property. I want to buy this property. What purchase contract do I use to buy a mixed use property? The answer until recently was you actually need 2 forms. You need a residential form for the residential part. You need a commercial form for the commercial part. Finally, no longer. We have a mixed use purchase addendum. So you'd write the offer on a residential purchase contract and attach the mixed use purchase addendum to deal with the commercial part. That's 4 forms, 3 more to go. Have you ever been in a transaction and the other side gives you this form that you've never seen before? It's not a CAR form. It's not a PRDS, it's not a San Francisco form. It's not a realtor. It's not a board of realtor forms. It's just a form like the broker made up themselves or something. So it's a non-realtor created form in the sense of a created by an association of realtors or something. Are you responsible as a realtor to be able to understand and explain a non-CAR form or non-PRDS form? The answer is no. Your standard of care is to understand the CAR forms. Some of you are thinking to yourself, that's a problem because I don't understand the CAR forms, but that's a different question. Not getting into that right here. But the point is, they give you this form, you've never seen it before. You're not required to be able to explain it to your client. So we have a new form. Use of non-standard forms advisory. You would give it to your client and say, you see this cockamamie form here I've never seen before? I don't understand it. If you want to understand this form, get your own legal advice. You don't have to do this, but you have the option of doing it. By the way, the other side gives you this form that they made up themselves, and they say, you need to give this to your client, and the client needs to sign it and send it back. You say, no. Do you have to do that? Do you have to give your client their cockamamie form and have them sign it and return it? Well, you got to give your client the form. You never, ever, ever hide anything from a client. If the other side has something they want you to read, they want your client to read, you're going to send it to them. But it's not required that your client has to sign it and send it back. They might not want to sign it. And then the other agent says, yeah, but if they don't sign it and return it, my broker says I don't have a complete file and I won't get paid my commission. And you say, that's not my problem. Because that's the kind of mean person you are. But the point is, you don't have to do it. Or you can say, you can look at the form and say, it's okay. Maybe you like the other agent, you want to help them out, so you have your client sign it. Maybe you don't like the other agent. Has this ever happened to you? You had a deal with the other agent you just don't like? This is your big chance to stick it to them. Don't sign it. Anyway. Yeah, go ahead. Yeah. Right. Right. Yeah, I mean, that's a different issue, really. Or San Francisco, you got to use their form. I mean, point number one, listing agents have to present all offers to the seller, no matter what form they're on. On the other hand, the seller, and of course it's going to be driven by the agent, but the seller can also make a decision. I'm only going to respond to and look at offers on a particular form. They have the right to make that decision. And if that's the case, then you're going to have to you're going to have to figure out that form. That is a realtor form. That's not a private form. That's a form endorsed by a realtor organization. So yeah, that can come up. And you're right. If you deal with builders, they're going to require their forms. Are you required to understand the builder form? No, but if you want to be doing business with that builder, you probably should get an attorney and help you figure it out so you can do it. Okay. Okay. Two more forms before we talk about the brand new ones. One of them deals with, it's kind of interesting. Okay, let's go back in time. Unlike anyone else in this room, I'm sure, I started doing real estate before, get this, before email. You young people are thinking to yourself, really? There was life before email? Yes, there was. Can you imagine doing life without email? We had fax machines, but yeah, they're a poor substitute. The point is, back in the day, if I was an agent and I needed to give you something like an offer, an addendum, a disclosure, a contingency removal, I would usually actually physically give it to you. I would drive to your office. Maybe I would fax it, but it's better to physically messenger it or deliver it. Okay, that's fine. And that's no one could really deny that they got the form if you brought it to them and they signed it before you took back a copy, everything had carbon copies and stuff like that. Then email happened. Of course, we immediately got lazy. I'm not going to physically deliver you a hard copy. I'm going to email you the form as part of an attachment. What's the problem with that? The problem is, if I send you an email, what if you say, what email? I don't think I got it. You must have sent it to the wrong address. My computer might not have been working. Maybe in my spam folder. Or what if they say, yeah, I got your email, I didn't open it. So if I send you an email, but you don't open it, has it legally been received? You are not going to believe this, but there's no clear answer to that question. Some courts have said, if you send them an email and they're aware that it's in their inbox, they've received it even if they haven't opened it. How on earth are you going to prove that they are aware that there's an email in their inbox? Which is why, for the last 30 years, I've been telling realtors, when you send an email to the other side that's important, you need to follow up. You need to get them to respond and say, yes, I got your email. On the purchase contract, all these years until now, right underneath where the buyer signs, there used to be that box called acknowledgement of receipt, right? So we've always educated you, send the offer, seller, if you have your seller accept it, send it back to the buyer's agent. And then buyer's agent, you initial the acknowledgement of receipt and send that back to the listing agent. So everybody knows you definitely received the acceptance. You might have noticed no longer on the purchase contract, underneath the buyer's signature is the acknowledgement of receipt. What the heck happened? The fine print of the purchase contract now says, if one side or the other delivers a document electronically to the designated electronic delivery address on the form, it is legally considered delivered as soon as it is sent. So if I'm the listing agent and you're the buyer's agent and you give me an offer or something that, and you put on the last page of the contract, page 16 in the broker box, you fill in that blank designated electronic delivery address. If I send you something to that address, the moment I press send, it is effectively delivered. What if you say I didn't open it? I don't care. What if you say it was in my spam, I didn't see it? I don't care. Since I sent it where you told me to send it, it is legally delivered. Big change in the whole, who has the burden of proving that something was delivered. Having said this, we've noticed that some agents are not filling in that blank on the last page of the contract. They're putting their name and their DRA number, their broker's name, broker DRA number, but they don't put in the email address they want things sent to. What if that is left blank? We're back under the old rules then. By the way, this all happened last December with the new contract. If that is left blank, then we're back to where we were before. In other words, if I send you an email, you can say I never got it and I got to prove that you got it, which is hard to do. So Forms Committee figured, let's make it simple to add that into the contract. So we have a new form called the Designated Electronic Delivery Address Amendment. The idea being, you're the listing agent, buyer's agent sends you an offer, and the buyer's agent doesn't put their designated electronic delivery address on page 16. Rather than have to counter the whole offer, accept the offer and later send him an amendment saying, hey, you forgot to put that in there. Could you put it in there? Of course, the agent may say, no, I deliberately didn't fill that in. I don't want to fill it in which case they're telling you, we're back to playing the old game of, you got to prove I got your email, which is the way it's been most of your life anyway. So anyway, take that for what it's worth. By the way, general comment. Do you know the difference between an addendum and an amendment? In real estate, we've used those terms interchangeably, but we really shouldn't. You know what an addendum really is? Think of it as overflow. I'm writing an offer. I don't have enough room on the offer form to say what I want. I'm attaching an addendum. Or I'm a seller. I'm sending you a counter, but I don't have enough room on the counter to ask for it, to demand everything I want. I'm going to attach an addendum to my counter. When that happens, by the way, that's all one document. You can't accept the offer and ignore the addendum. If you don't sign the addendum, the whole deal is off. Whereas an amendment is when you're in the middle of escrow, you've already agreed to a contract, you're in contract, and one side or the other wants to change what was already agreed to. Now, for most of your life, you've probably used an addendum to do that. What I'm saying is it's better to use our amendment form. We got a form called the AEA, Amendment to Existing Agreement. First of all, because the terminology in the legal world is addendum means this thing and amendment means this thing. The other good thing about an amendment is if I submit to you an amendment, it has a time frame. It basically says, this is what I want. Please respond. And if you don't respond in 3 days, you're basically saying no. Whereas if I submit my proposal on an addendum, there's no time limit. So I could wait forever for you to make up your mind if you want it or not. So ties it up. Okay. So we have some forms already on zip forms that seem to contradict what I just said. We got this commonly used form called the ETA, Extension of Time Addendum. where, you're asking the other side for an extension of the closing date or extension of a deadline to do something. Now, based on what I just said, shouldn't that form really be called the extension of time amendment? Guess what? We're changing the name. We're going to change the name of all of our forms that are called the such and such addendum that should really be called the such and such amendment. Does that mean you're going to get in big trouble if you continue to use the generic addendum form? No, of course not. But I'm just giving you the best practice. Okay. All right. Which leads to the last new form that came out in June. It's called, okay, background. I've got, this is the year of fair housing, all these, I've already mentioned a lot of things. You know what a restrictive covenant is? It could be part of the CC&Rs. It could be just a separate document attached to the deed that actually restricts what someone can do with their property or who they can convey it to. Some of these are legal, some of them aren't. Theoretically, I could, and used to see this back 100 years ago during Prohibition, I could sell you my house and record a restriction that says anyone who buys this house can never serve alcohol on the premises. First of all, how do you enforce that? Second of all, no one's going to do that today, right? But I mean, you can do things like that. Or this house can never be used to build a swimming pool. Or this house always has to be used by a charitable entity. You'll come across those things. They're enforceable. Sometimes they're in the CC&R, sometimes they're separate documents. But sometimes you'll come across one of these things that is clearly illegal. The worst ones say something like, this property can only be sold to Caucasians. Clearly unenforceable, illegal. So why do I care? Well, some people are offended by the fact that that's a recorded document attached to their property. It's bad enough that it's there. It's illegal, but I don't even want it to be there. I want it to be redacted. There's a new law that took effect July 1st that says every county recorder in California has to painstakingly go through every recorded document and remove illegal restrictive covenants. Now, this is going to take years, but the law also says if you happen to own a property that has one of these restrictive covenants, you can accelerate the process. You can march to the recorder's office, fill out a simple form, pay no fee, and the recorder has 3 months to remove that document. How does any of this affect you? The law also says if a realtor has a listing or a sale on a property that has one of these, racist, bad, restrictive covenants, you have to inform your client of their right to do what I just said. Go to the recorder's office, handle it in 3 months. So naturally, we have a form for this. What's it called exactly? I always forget. It's called, she remembers from this morning, disclosure to buyer or owner regarding discriminatory covenants or something like that. Anyway, the problem, not the problem, but you're probably not going to know about it anyway, right? How would you only have to give this form to your clients if you're aware of it. How would you be aware? The only way you would know if the property had one of these is if you dug down into the prelim and pulled up all the underlying documents, which you certainly don't have to do. In fact, I advise you not to do that. But maybe your client will discover it on their own. They'll say to you, hey, did you see this? And you're going to say, well, no, I didn't see that. But now that you told me about it, I'm going to give you this form, which informs you what your rights are. Okay. All right. Enough of the old form. Now let's talk about the future. Let's talk about December. First of all, do I know any new laws coming next year? I have no idea. This is the beginning of the legislative process. I will tell you, remember those bad ones I said at the very beginning that didn't get passed? I guarantee several, if not all of them, will be reintroduced. We have to fight these battles every year. Keep that in mind when you're filling out your, as Jody said, when you're being asked to contribute to the Realtor Action Fund. Okay. You may have heard there are these big nationwide things going on, these lawsuits involving organized real estate, generally on the whole commission idea. the allegation is the whole commission structure as it currently is violates the antitrust laws. Buyers should be paying their agents directly and sellers should be paying their agents. It shouldn't be listing agent, seller pays listing agent pays buyer's agent. That doesn't give the buyer any opportunity to negotiate their commission, blah, 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 blah. Okay. These are big time lawsuits. Antitrust lawsuits often take years. They go ups and downs. If it gets resolved, it'll probably be a long time, and NAR may then support legislation to change it to what we want. I have no idea where any of this is going. I'm just going to tell you a couple of forms responses to that. One of them is there's a proposal that to be able to get paid as a buyer's agent, it should be required that the buyer at least signs a contract saying you are my agent, sort of like a listing. This is not required yet. It may never be required. But did you know we already have buyer broker contracts? We have 3 of them. One is like an exclusive listing. It says the buyer signs it, and the buyer is saying to you, if I buy anything in the next 90 days, I will make sure you get paid 3% or 2.5% or whatever. It doesn't mean they're going to come out of pocket to pay you. It means if, for example, the listing agent is only offering you 2%, the buyer will make up the difference or something like that. Then we have a second one, a non-exclusive one. It says the buyer signs it with you and they say, if I buy anything with you as my agent over the next 3 months, once again, I'll make sure you get paid at least, 2.5%, whatever it is. And the third version we have is simply, there's no money involved. It just says, we're signing a contract where I agree I'm your agent and you're my principal. It's not exclusive, but at least we have an agreement. Like I said, possibility one day that will be required, not yet. What am I telling you though? Well, here's what's going to happen in December. Those 3 forms are going to be combined into one. So it would start off as just a representation agreement, and then you could check a box and say it's also it involves money, involves a commitment, either exclusive or non-exclusive to pay. Okay, so if any of you ever use, the 6 of you in this room, have any of you ever used a buyer broker contract? See, they're not commonly used in California. Some states, by the way, no agent would show a buyer a property without getting a contract first. It's not like this everywhere. Who knows, that may be the case one day in California. The point is we have a form for you. All right. Second form, there's one new disclosure form coming out that is not required by law. It's a good form. It's called the Solar Advisory and Questionnaire. The idea of this form is you're selling a house that's got solar panels on it. Buyers have no idea what that means. It's educating the buyers on what does solar panels mean? What does it mean to own them? What does it mean to lease them? Blah, blah, blah. It's a good form. If I were you taking a listing on a solar property, on a property with solar panels, I would use it. Okay. All right. So that's 2 new forms. Third new form. Not required. None of these are required. Third new form is, okay, scenario. You're working with a buyer. Normally, how do you get paid? You're writing an offer on an MLS listing and you're a member of that MLS. That means the listing agent offers you X amount portion of the commission. If your buyer's offer is accepted, you get that amount. The listing agent has to pay you. You know that. But occasionally you'll come across a scenario where you're representing a buyer to buy something, but it's not an MLS listing. One possibility is it's listed, but it's not in the MLS that you're a member of. How do you get paid in that circumstance? Well, you can go directly to the listing agent, say, I got a great buyer, but you're only going to see it if you agree to pay me. I got this form for you, CBC, Cooperating Broker Commission. Okay. Another scenario is like a for sale by owner, where there's no listing. There's no listing agent. How do you get paid in that scenario? One possibility is your own buyer pays you. This might be the wave of the future. You never know. And obviously we got a form for that I just talked about, the buyer representation agreement. But there's a third possibility, and that is I'm representing the buyer and I want the seller to pay my commission, even though there's no listing involved. I mean, I can try to convince the seller to do a one-party listing, but the seller says, I'm not signing a listing. No listing. But they might still be willing to pay the buyer's agent. Well, can I just write on the purchase contract, buyers saying they want the seller to pay the my agent a commission? You can't. That violates the law. Commissions have to be on a separate form. You can't just incorporate it into a purchase contract. It has to be in a separate document. Hallelujah, we have a new form. Seller payment for buyer's broker. So you may never be in this situation, but if you're ever in a situation where you're representing a buyer, but you want the seller to pay, it could even be the scenario where, back to my buyer's agent scenario, where the MLS offers you 2% and you want 3%. And your buyer is not going to make up the difference. You want the seller to make up the difference. You can do that. We now have a form where you can ask the seller to pay you. And we have a new checkbox on the purchase contract where you check the box, see attached seller payment for buyer's broker form. So you can incorporate it into the offer, but it's legal because it's on a separate form. And if the seller signs it, they got to pay the buyer's broker. And obviously they got to pay the broker, not the agent. Everything's all compensation goes to the broker. So that's a nice form. You may never need it. Finally, remember I'm talking about all these potential changes that are going to happen in real estate? Another issue is, let me ask you a question. I'm going to ask the 6 people in this room the question. I already know what your answer is going to be, but I'm going to ask you anyway. When you're representing a buyer, do you normally tell the buyer how much you're getting paid? You're saying yes. He's the only guy, and this room was full this morning. Nobody said yes. It's not a normal thing. I'm glad you do it, but it's not normal. Well, let me ask the rest of you, the other 5. Does a buyer ever ask you how much they're getting paid? I think if they did, of course, you better tell them. Yeah, right. They want how much they're going to get back. But the point is, it has not become a common thing in California for buyer's agents to volunteer to their buyer, you know, I'm getting X amount of money in this deal. Hopefully, if they ask you point blank, you do tell them. Well, there's a proposal that this might be required. In fact, the MLSs, or some of the MLSs now, I think yours even, is publishing that. So the buyer can figure out, if they're resourceful enough, how much you are getting paid. But the law could change, or the code of ethics could change, that actually requires you not let the buyer try to figure it out by looking at the MLS. It might require you to actually bring it up and actually say to your buyer, well, if you buy this house, I get paid this amount. If you buy this house, I get paid this amount, et cetera, et cetera. This might not happen. But if it does, we're ready. We got a form. Anticipated broker compensation disclosure. I want you to realize when you get the announcement from Zip Forms that these are the new forms that are coming out, and you see that there, it's not required. I personally don't think it's a bad idea, but with full transparency and things like that. I think if agents started doing these things voluntarily, these big lawsuits would probably start to go away. In any event, that's not the issue. So that's a form that's come out. Now, are there other forms that are going to come out in December? Probably. The Forms Committee is working on these as we speak. They're not done yet. They're almost done, but more could happen. I do know what I'm not going to talk about today is they did make a bunch of changes regarding The property management forms, that's going to be tweaked. The lease agreement is going to be tweaked. The application to rent form is going to be tweaked. I'm not going to turn this into a property management seminar. I don't have time. The pre-move out inspection form is going to be, they're going to have nice changes. The rental property owner disclosure, that's sort of a new form, a disclosure by not landlord, but because believe it or not, landlords like sellers do have some disclosure obligations. For example, the lead paint form. So if you're in the property management business, new forms will be tweaked. Look forward to that.
Got a question.
Yes.
So this came in earlier, but I think it fits. Too many buyers agents agree to rebate their buyers the commissions they will receive from the listing agents. Is there a form for that?
No, good question. First of all, it is legal to rebate to your buyer money. I mean, you don't like it, but it's perfectly legal. We don't have really a standard document though. And the reason it should be put in the contract is because you have to disclose this to the lender. And the simplest way to disclose it to the lender would be on the purchase contract, because the lender looks at the purchase contract. So technically you wouldn't actually have to put it in the contract. You could separately tell the lender, why not put it in the contract? Absolutely right. No, we don't have a special form for that.
One more, and I hope I get this correct. So to the person who asked it, but I don't, let me know. So the contract RPA and addendum / counter offer are prohibited to talk about agent's commission.
Okay, the code of ethics says, and by the way, we checked this. So this new form I talked about doesn't violate this. The code of ethics says you can't try to renegotiate or initially establish a commission in that form. And I mentioned that before. So not only is it not enforceable, it's not ethical to try. But we've definitely checked with NAR. It's totally okay. This new thing that I said, where you attach an addendum to the purchase contract on the form, the new form I mentioned, asking for the seller to pay a commission. That's definitely okay. It's definitely going to be okay. Last thing I want to mention, or two more things, is are there any forms that you use regularly that have, as opposed to new forms, are there any forms you use regularly that are going to change? Well, I already mentioned the property management forms. Any other forms that are going to change? Not really. The cancellation form has a new box that you're basically saying, if you're going to cancel the contract before the deposit has ever made it to escrow, you check a box that we're canceling. And it reminds the parties, just because there's no money in escrow doesn't mean there's no financial penalty for canceling. You're still under a contract. Especially, let's say you make a non-contingent offer, you've received all the disclosures, and then the buyer cancels. Well, they have no right to cancel. They can get punished. I never put the deposit in. So what? You're still under contract. The seller can still sue you for damages. Or maybe you got to pay a cancellation fee to the title company. The point is, it's just going to be educating your clients. Just because you're canceling before there's a deposit doesn't mean there's no financial consequences to that. Okay. A couple other things aren't even worth mentioning. The purchase contract, the form that just got changed back in December, has a couple of little tweaks. Since that's the form you use more than anything else, you should know about them. Remember I talked about contingencies a second ago? Loan contingency. On the very first page of the contract, in the box there, if you're not a cash buyer, you're telling the seller what type of loan you're trying to get. The purpose of that is because if you try to get out of the deal based on your loan contingency, you have to prove to the seller you didn't qualify for the loan you said you wanted. So here's where you say the loan you want. You say, I want interest rate not to exceed X. What about points? The current form says, my offer is contingent on getting a loan with 0 points. Turns out most lenders don't allow it. Most lenders want at least 1 point. So that makes it too easy for the buyer to get out of the deal. So now it's going to say, buyers saying the loan I'm trying to get, interest rate not to exceed blank and points not to exceed blank. Not as a fault, as opposed to defaulting to 0 points. That's one change. The other change, a couple more things, as I said, there's going to be a default if you don't do the tenant occupied purchase addendum and there's a tenant in the property and you don't do that form, you're basically saying, first of all, it's trying to remind you to really use that form. It's trying to remind the seller, if the buyer doesn't attach the TOPA, seller, you should attach it to a counteroffer. It spells that out. But it also says, as I mentioned before, if you don't use the TOPA, both sides are agreeing the property will be vacant at close. These are tiny changes, not even worth mentioning. I think it mentions the new solar form in the purchase. It's not required, remember. It mentions that seller payment of buyer broker form if you want to attach it. The only other thing is, and this is interesting. Have you noticed, you've noticed this forever, deadlines in your escrow. I got 17 days to do this. I got 45 days to close. I got 3 days to do this. All these deadlines, how do you figure out the deadline? Well, the day of acceptance is day 0, typically. And then you count days, right? 12 days, 17, however many days you count. And you count Saturday, you count Sunday, you count holidays. But then the deadline itself, the 17th day, the 10th day, the 45th day, what if it falls on a weekend or a holiday? Well, deadlines cannot fall on holidays or weekends. So if you're supposed to close on Sunday, the 45th day is a Sunday, you close Monday. What if Monday's a holiday? Then you close the next business day. Here's the problem in California. What is a legal holiday? We got a lot of holidays in California. They just added 3 more. I think they just added Juneteenth. They added like Indigenous persons, something or other. We've got Cesar Chavez Day. Are these holidays for purposes of this contract? We got Halloween. Is Halloween a holiday? It should be. Does that mean if I have a deadline next Monday, I don't have to do it next Monday? What's the answer? We've never really had an answer. The form is about to have an answer. We could have listed in the contract every holiday, but they keep changing. So it now says in the definitions, a holiday means it's a holiday as described in California Civil Code 7.1 or California Government Code 6700. Some of the holidays I mentioned are listed there, some of them aren't. You can always call the hotline or just simply Google California Code. It will list, and the holidays listed there are the days where the deadlines in this form cannot fall on. All right. Now, there's one thing I'm going to say to you that I didn't say this morning because I ran out of time, but I didn't run out of time today. So I just got to ask you. In the area where you guys work, do you ever have listings that are in high or very high fire zones? Probably not in the city of San Jose, maybe, but yeah, okay. You understand, right, that there's this form called the fire hardening form. You understand every time you take a listing, you have to determine what type of fire zone your property is in. There are 4 possibilities: very high fire zone, high fire zone, moderate fire zone, nothing. I suspect most of the city of San Jose is probably nothing. Although I know San Jose stretches out into the hills and stuff. The point is, you may take a listing that is in a high or very high fire zone. If it's in a moderate zone or nothing, you don't need this form. If your listing is in a high or very high, you need this form. So the next question is, how do I know when I take a listing if my listing is in one of those forms? You could, if you wanted to, pull out this form electronically, go to the link on the first paragraph that links you to the CAL FIRE website, And you can try to figure out the maps, they're different colors, figure out which one your property's in. Better yet, look at your NHD report, which is required on every deal. The NHD report on the signature page has 2 earthquake zones, 2 flood zones, 2 fire zones. The 2 fire zones, one says very high fire zone, one says wildland area. These are required that the NHD tell you. If neither box is checked, you're not in a fire zone, this form is not required. If the very high box is checked, you're in a very high zone, the form is required. But the other box on the NHD form says wildland area. So that's checked, let's say. What have they just told you? They've just told you you're not in a very high zone and you're not in a nothing. You're either in a high or a moderate. But Gov, you just got through telling me that this form is required if I'm in a high, but it's not required if I'm in a moderate. So now what do? I don't know which one it is. You go back to your NHD provider and say, thanks for telling me that I'm in a wildland area. Now tell me specifically, am I in a moderate or a high? They have that information. They can give it to you because they looked at the maps themselves to figure out what they did tell you. They can tell you more than that, and they should. CAR is sponsoring a bill next year that would require them to break it down into high versus moderate. That is not currently the law, though. My experience with NHD companies are only about 10 or 12 in the state. Most of them will tell you. What if they won't? What the NHD company says, well, I don't know, I don't have to tell you, blah, blah, blah. Number one, think about a different NHD company. Or number two, that means you, the listing agent, got to go to this website, look at it, try to figure out by looking at the CAL FIRE map whether your listing is either in a high or a moderate zone. Okay, now let's say you figured out you are in, definitely your listing is in a very high or high fire zone. You're probably not in San Jose, but you could be nearby. High or very high, what do you do? Well, now you need to fill out this form. How do I fill it out? There's paragraph 2, there's paragraph 3. Paragraph 2 is pretty easy. There's 6 questions for the seller. Yes or no. Are you aware, seller? Do you have a wood roof? Do you have single pane windows? Do you have landscaping within 5 feet of the house? Do you have non-metal gutter covers, etc.? Answer yes or no, very easy. What if the seller says, I don't know. I don't know what type of gutter covers I have. Then put no, you're not aware. Seller's going to say, I want to write, I don't know. Well, then write it in if you want. Knock yourself out. But don't skip the question. This is a good tip. Whether your seller is filling out the TDS, the SPQ, the lead paint form, the NHD, or this form, never skip a question. If you skip a question, the form is not complete. Even though you give it to the buyer before escrow opens, the way you guys do here, and they acknowledge they received it, they've acknowledged receiving an incomplete form. They still have their right of rescission. That's a general tip. So far you're with me, right? We figured out when to use the form. Seller has to answer 6 questions, yes or no. Now we get to the confusing part. Paragraph 3, defensible space. If your property's in a high or very high fire zone, you have to have 100 feet of defensible space that is defined clearly in the Public Resources Code. What does that mean to have 100 feet? It means the grass can't be more than 4 inches high. It means the trees have to be the branches have to be a certain distance apart. It's pretty clear. So your property has to be in compliance right now. It had to be in compliance last year, 2 years ago, 5 years ago, next year. You always have to be in compliance. If you're not in compliance, CAL FIRE can come out to your property, or the San Jose Fire Department can come out and they can say, oh, we've looked at your property. You need to cut that tree down. We'll be back in 2 months. If that tree's still there, we're going to fine you. But that could have always happened. That's what you live with. This law is saying, not only is that the law, but when you sell a house, either this in a high or very high fire zone, either the seller or the buyer has to proactively reach out to the fire company and arrange an inspection. It's not wait for them to come to you. You got to reach out to them.
Question.
Let me finish my thought. if it's about this, because that's a good question. I know what it's going to be. So the question is, well, whose responsibility is it to do that? Is it the seller's responsibility to arrange for this inspection before it closes? Or is it the buyer's responsibility to arrange for this after it closes? I will guarantee you in Santa Clara County, it is never the seller's responsibility. In San Francisco, in Alameda, in San Mateo counties, it's never the seller's responsibility. There are certain places north of here, Truckee, Paradise, a few other towns, where they've specifically passed laws that say, here, it's a seller responsibility to do it before close. CAL FIRE and the local fire companies sometimes get confused, and they're going out in some places telling people, oh, you can't sell a house around here without getting an inspection. If you're not in the places I just mentioned, that's false. But remember, they could come out anyway, regardless of this law, and just inspect your house because they feel like it. But don't let anyone tell you that it is a seller responsibility. Which is why I recommend, if your listing is in this high or very high fire zone, when you come to paragraph 3, C, and it asks you, you have 6 choices of who's going to take responsibility to do this and when. Don't check any of the boxes. If you don't check any of the boxes, it defaults to number 1, which says the buyer within 12 months after close will take the responsibility to do this. Having said this, there's nothing to stop a buyer. As we turn into more of a buyer's market, there's nothing to stop a buyer to fill out a request for repair and say, part of my request for repair is, seller, you need to go arrange to get a defensible space inspection and get certification that the property is in compliance before I buy your house. Seller could say no. Buyer said, I'm not gonna buy your house. So we're starting to see that happen. Back in the seller's market, which we're still sort of in or not in, sellers typically, no way I'm gonna do that. Your responsibility. But I'll tell you, legally, it's not the seller's responsibility. Sellers nowhere where you work ever have to do anything prior to close. The buyer can try to negotiate that. So just want to throw that out there. It causes so much confusion. The form's kind of hard to figure out. I tried to simplify it for you. You'll be glad you're not in some counties that I go to where every property is in a high or very high fire zone. I mean, every property. There are many counties like that, mainly north of here, east of here. And this is all we talk about for a half hour because it's interesting. But any questions? Say a question.
So a buyer has a property inspection contingency and never removed it. It's past the closing date and the seller has issued a demand to close. The buyer has not responded. Can the seller cancel the transaction and keep the deposit?
Great question. Those are actually 2 questions. Number 1, buyer has not removed the investigation contingency. Not only that, they didn't close on time. Seller wants to cancel this buyer. The right thing to do is what they're doing is sending them a demand to close. 3 days later, if the buyer doesn't close, seller can cancel the deal. But can they keep the deposit? Generally, no, because they still have a contingency. Now, the seller can make the argument, why didn't you remove that contingency? I don't think you're acting in good faith. I mean, if the buyer comes up with some cockamamie excuse like, well, my inspector was delayed and I needed a follow-up inspection and I couldn't get it arranged, and that's why I didn't remove it on time, maybe they're acting in good faith. They can still be canceled. But I mean, what I'm really saying is, in that scenario, the seller can say, I'm canceling you and I want your deposit. And the buyer is going to say, well, you can cancel me, but I'm keeping the deposit because I never removed my inspection contingency. And they may disagree. Seller says, I'm not releasing the deposit. Buyer says, I'm going to sue you if you don't release it. Now, you can let a judge decide what I just said. A judge can analyze whether this buyer was acting in good faith. It's possible that the seller would win that argument and the judge would order the deposit released to the seller. It's also possible that the buyer would convince the judge I was acting in good faith. It's not a question of, I didn't remove it. And theoretically, they could give it back to the buyer. My experience is usually they give it back to the buyer. In that scenario, it might not be worth the seller's time to hire a lawyer. First of all, I ask them how much the deposit was. If it was 10,000 or less, don't give it back. Let them take it to small claims. You would have to pay $1,000 penalty if you're found to have not released it without a good reason. But if the deposit's more than 10,000, is it worth hiring a lawyer to sue to get it? I mean, maybe. What if the buyer and seller simply don't agree? They don't hire lawyers, they just don't agree. The title company is going to hold the money indefinitely until one side or the other tries to file some type of legal proceeding to get an order to release the money. So in that case, it may be worth getting a lawyer to do it. You never know. Okay.
I have another question, and then it just economically here in the Bay Area, I don't know if you follow, but several companies have had big layoffs. There are rumors that Twitter may have 75% in reduction of force. So this question is, a buyer has accepted an offer with property and loan contingencies. Now the buyer is concerned about their future employment and wants to back out. Can the seller refuse to cancel and return?
Yeah, I mean, that's a
deposit?
common question we're getting on the hotline. Buyers seeking to cancel based on economic conditions, future uncertainty. Sorry, that's not one of the 8 contingencies. In other words, you'd have to say, I mean, in this scenario, if the buyer has not removed their contingencies, they can probably figure out a way to get out. Maybe they can come up with a problem with the property that the seller won't fix. Maybe they don't qualify for the loan. But if a buyer is simply saying, I want to cancel and get my money back solely because of these economic conditions we're in, that's not a specific contingency. So we get asked this on the hotline a lot now. It's just, nope, that's not grounds to cancel.
Going to the question of loan.
Yeah.
Put in my contract, I'm gonna get $1 million loan.
Right.
At X
Right.
interest rate, not gonna receive one.
Right.
I don't qualify for that $1 million loan, I only qualify for 950.
Right.
And I cancel.
Absolutely. Absolutely. No problem at all. By the way, are you seeing people put in, have you noticed on the appraisal contingency now, you can make the property contingent on the property appraising at less than the purchase price? Which is, you're basically promising to make up the difference if it doesn't appraise. We're seeing that. Yeah. Yeah. So in other words, you're saying the seller's saying to the buyer, yeah. In other words, they don't want, the seller is saying, we're not going to look at your offer if you have an inspection contingency or something like that. Yeah. So you try to put 0. It won't. You know what you have to do? You have to attach the CR form, the contingency removal form, and you check the box that you're removing that contingency. Yeah, that's good. That's good.
Ask of what he was referring to, 5 days of right of recession. TDS is 3 days.
Okay, there are 5 disclosure forms that give the buyer a right to rescind. NHD, TDS, SPQ, lead paint, and fire hardening. How long is the buyer's right to cancel? It is 3 days if the disclosure is delivered to their agent in person. It is 5 days when it's delivered electronically or by mail. nobody delivers things in person anymore. So I skipped the 3-day part and just said 5 days. So that's probably what they're thinking about. I said 5 days because it's always 5 days because nobody delivers disclosures in person anymore. Am I right? Yes. Any more from the peanut gallery? Bye, people on Zoom. Bye. 4 people left in the room.